Okay, good afternoon, everyone, and welcome. My name is Meredith Fortin, and I'm the Asylum Program Officer here at Physicians for Human Rights. I'm so glad that all of you could join us for the webinar. You should all be able to see our screen right now, the slide presentation, and hopefully you can hear us. Let us know by raising your hand if you're having any technical difficulties accessing the program. Looks like we're good. We're going to be recording the webinar today, so anyone who can't attend, as well as anyone who did, will have access to the recording after we're finished. We have nearly 100 folks that we're expecting today, about 60 so far on the line. That's pretty exciting for us. I recognize some longtime partners on the list of attendees, and I think there are also some of you who are new to working with the Asylum program. So I'm really glad you could all join us. I think this will be a good use of our time. After the conclusion of the webinar, we will be sharing both the link for the recording and the presentation itself, so you'll have access to both of those. Okay, so why are we doing this? Why did we decide to hold this webinar? We want to make the process of working with the Asylum program easier for immigration attorneys to understand and navigate. So our goals today are to gain, for you guys, to gain inside understanding of the Asylum program's process, figure out how you can maximize the chances that your client's case will be placed with a volunteer, and also just get some tips on how to work effectively with the volunteer clinicians. We have some materials in addition to the slide presentation for you. You should all be able to see a handout drop down there, so you should have access to 4 handouts right now. Those are our current intake form, a document that we refer to as our overview of services. It's a 1-page explanation of the program, our case outcome form, and also a sample case placement email. And we're going to touch on all of those in more detail as we go through the presentation. Also, I want to address how we're going to try to handle questions during the webinar. As much as possible for time, I'd like to try to save questions towards the end. We've left some time for those. And as you have questions, or at the end, if you have questions, please use the questions text box to fill out your questions as opposed to raising your hand. I think that'll help us manage the questions much easier and make sure that we get to everybody and that everybody knows what questions there are that we're going to be addressing. Okay, I want to start by giving just a brief overview of Physicians for Human Rights. I think that for a lot of people, your only work with PHR is through the Asylum program. I think it's good to know that we're just really a small part of what Physicians for Human Rights does globally. So the Asylum program and all the other programmatic work that we do are focused on PHR's mission using science and medicine to stop human rights abuses. A lot of the work that we do is documentation using those tools of rights abuses, but we don't just do it domestically. We have both a domestic and an international anti-torture program working on training and documentation of torture around the world and in Guantanamo. We have a program that works on sexual violence in conflict and post-conflict zones and the documentation of it. We also do death investigations around the world and mass grave exhumations. So Asylum fits really naturally within those programs, but in some ways it's also quite distinct because it's so based in domestic immigration law. So now looking at a snapshot of the Asylum program, our mission is to protect the right to seek asylum and support access to justice for asylum seekers and other immigrants. We do this through facilitating pro bono forensic evaluations. I think you all know those evaluations are both physical and psychological. We do them for affirmative cases, defensive cases, and some cases that are not asylum applications, T visas, U visas, VAWA, et cetera. And we work with detained and non-detained individuals. In addition, we work through the data we collect through our documentation to do research and advocacy in support of that mission. All of the evaluations we provide are pro bono, and we know that they make an enormous difference in case outcomes because we track case outcomes. Okay, so who are we in the Asylum program? You'll see that it's quite small. Myself and my colleague Janine Sawan are the 2 members of the program, and we work to keep everything running. I think many of you have corresponded with one or both of us already. Our contact information is there. I've also provided the contact information for our general intake, our general inbox, asylum@phrusa.org. A couple of things. We wanted to make all the contact available to you, but how I encourage you to use this is when you're submitting an intake form for a case, and we'll talk about how you do that, only send it to the Asylum inbox. And if you're following up on a pending case, only send those questions to the Asylum inbox. That helps us keep all case correspondence together. Other general questions or concerns, please feel free to reach out directly to the team, and we'll do our best to help you. Something I neglected to mention when I spoke about questions today, but it's appropriate here as well. If you have questions that you bring to the webinar that are about a specific case or something that happened in the past with a specific case, this probably won't be the best forum to address them. We're not going to have access immediately to the details. We'll be happy to follow up with you if you reach out privately after the webinar. But we're going to try to keep the questions today focused on sort of general issues around our process and principles and things like that, so they're valuable for all the attendees. Okay, so besides Janine and I, we also work with what we call the Asylum Network at PHR, our volunteers. That's over 500 volunteer health professionals around the country who have been trained to do this work. And you'll see it's a really broad array of professions. It's not just, despite our name, it's not just physicians that we work with. All volunteers need to apply for membership, so we know who they are. They need to be trained or mentored in doing this work, and they have to be licensed to practice. So thinking about the size of the team and our volunteer network, it's just really good to keep in mind that we're a small team and our resources are really limited. It's an entirely volunteer-based service. Our volunteers also aren't equally distributed around the United States. They tend to be concentrated in certain metro areas, more on the East Coast than the West Coast, although we're working to change that. And so a lot of what we do and a lot of the processes that we've developed and that our predecessors have developed are based on figuring out how best to marshal those limited resources for the cases that need them the most. So the rules that we have and the things I'm going to talk about today weren't developed arbitrarily. They're our best effort currently at making sure that we can do the most work most efficiently. You'll also see here that I have a reference to medical school clinics. Some of you may have worked with our medical school clinics before. There are right now about 7 in the country. That number could double next year. We're working to open some more. These are student-run clinics at medical schools with which some of our volunteer members work and to which we direct some of the cases that we receive. At these clinics, students are observing evaluations, assisting in report drafting, and assisting with logistics. And in doing that, we're able to take some of the workload off of volunteers and hopefully allow more volunteers to engage more frequently. So it's a great collaboration. If you are interested in working with a clinic, you can certainly raise that when you submit an intake form. There's no requirement to. You'll note that if you look on the second page of our intake form, we check to make sure whether or not a particular client is comfortable having a student observe their evaluation so that we never direct a case to the clinic that shouldn't be sent there. Okay, so what is it that we are doing here in the Asylum program? There are a couple of different components of the work. One is just training, recruitment, and volunteer management. There's a lot that goes into that, especially the more that our volunteer network grows. We provide several trainings every year around the country in areas of high need. And then there's our case screening, processing, and volunteer outreach. I'll talk a bit about that today, and that's the mechanics of how we receive your requests and manage them and get them out in front of volunteers. Finally, we provide affidavit review, mentoring for our volunteers, and general troubleshooting for both volunteers and attorneys. And at last, there's our data management, our collection and analysis of all the information we have about the clients who pass through our program and their case outcomes. And we want to be able to collect more of that and use it effectively for research and advocacy on the mission that I think all of us share. A couple of notes about what's going on now for the Asylum program. So within the last 18 months, we've really had an explosion in demand. And over the last, I would say, 4 to 5 years, a bit of a shift, an expected shift in the client population. Right now, we're receiving about 1,000 requests a year from attorneys around the country who need forensic evaluations. Well over half of those cases at this point are for clients coming from the Northern Triangle. I doubt that would surprise anyone on the webinar right now. These clients are younger, they've experienced more sexual and domestic violence, and they've experienced it at younger ages. And that has implications for our volunteers and for our training and our capacity to respond. These are often more complex traumas, and so they require a certain kind of expertise. Right now, psychological requests make up at least 75% of our total work. So that has been a growing trend, and again, I doubt a surprise to anyone on the call. That's mostly what you need, and for most folks who need a physical evaluation, they will also need a psych. I think it's pretty natural. For the country, our three biggest areas of demand and work are the NYC metro area, DC, Baltimore, and California. Those, I think, probably the three combined are a huge proportion of the work that we do, although we're also working in lots of other places in the country. And I wanted to share this information with you all because it's good to be aware of where the network is a bit overtaxed, right? If we have a youth case, a psychological request in New York City, that's sort of like the greatest oversubscribed type of case. And so it might be more difficult for us to place that as quickly as we could do other types of cases in different places. So this could, of course, shift, but given what I know about the network and the demand behind this, I don't expect it to. If anything, these trends will probably continue. Okay, so into the meat of the program today, I'm going to spend a bit of time talking about our process. That's where I would really like to give immigration attorneys that work with us some insight into what our process works like and then allow you to strategize in response to that. We'll also go over some common questions and mistakes that we see and some general do's and don'ts for submitting cases and also working with attorneys. So we're going to start with our basic process. This is quite a busy slide. There's a lot here. This is our attempt to condense the entire life cycle of a case with the asylum program, starting from your completion and submission of an intake form to the asylum inbox, and ending when you notify PHR and the volunteer or clinician of the hopefully positive outcome in the case. So that was a busy slide. I want to now break it down into essentially four big components of this process. Submission and screening of intake, our outreach to volunteers, collaboration between you and the volunteer clinicians, and then working on reports. These are the places where things are sort of most likely to go wrong. Okay, so starting with our intake process. All of you have right now access to our current intake form. It's also available on our website, and when we send you these slides, you'll have a link to where it lives on the website. If it's ever updated, it will be updated on the website as well. This should be completed by the attorney. I think most folks do that, but sometimes we see it sent in by clients. If you've filled out the form or if you're looking at it right now, I think it's pretty easy to see why having your client complete it isn't a good idea. There's some technical questions that often confuse clients, and it's less likely to be completed completely and accurately. So make sure that you're the one filling all of this out. And then you'll see the form itself. We worked very hard to keep it short and keep it clear. So there's a lot on those 2 pages, but there are also instructions for most of the questions. And there are instructions on how you want to submit that. It goes right to our asylum inbox. We don't accept intake forms by fax. We don't accept them by mail. Our processing times, ideally for us, is 3 business days before we're reaching out to you to confirm receipt. But I imagine that most of you have experienced longer wait times. When we have greater volumes of requests and requests that require more work on our end, processing times slow down. We're always pushing to try to get them shorter. And part of what I want to talk about is how you on your end can maximize the chances that your case will move through quickly. Besides volume delays on our end, things that slow down case processing are just errors in the intake form. If you're carefully reading the intake form and following the instructions, you should be fine. But there are things that generally tend to happen: lack of response to the question about consent, lack of travel information, deadlines, forms being handwritten, and then unclear referral questions. I think most of these are pretty self-explanatory. The 2 biggest issues are deadlines and forensic or referral questions, and I'm going to talk about those in more detail. So, deadlines. First, let's just define what we mean at the Asylum program when we're talking about a deadline. If you take a look at the second page of our intake form, you'll see that we ask for the date by which you need a final version of the affidavit. That, for us, is the deadline that we work with. So when we talk about a deadline, we are not referring to the date by which the evaluation takes place or the date by which you want to be matched with a volunteer. No, for us, that's the final date on which you need that final document, and that is what volunteers are told to understand as well. So that's just one point of clarification. You'll also see on the intake form that we specify we require a minimum of 8 weeks notice before that deadline. So when we receive the case, we need that deadline to be at least 8 weeks in the future. This is our minimum, and we've set it because in our experience with a shorter deadline, it is extremely unlikely that we will be able to process that case, find a volunteer who can see the client and write the report before the deadline arrives. So this is our minimum processing time, but it is not a guarantee that all cases can be placed in 8 weeks. We're quite sure that many of you have waited longer for that, particularly those of you who work in areas where there's a real imbalance between demand and volunteer availability. So the longer you set out your deadlines, the better it is for you. I think sometimes this is counterintuitive for attorneys. And the reason this is we'll talk more about volunteer outreach, but we work with an entirely volunteer network. When they receive a potential case, they're looking at the deadline and considering whether they could potentially fit it into their work schedule. The vast majority of our volunteers work full-time, they're seeing patients, they're teaching, they might have private practice. They may need 6 weeks to simply fit a 2.5-hour evaluation into their daily schedule. So the shorter a deadline gets, the fewer volunteers there will be who can potentially take this on, and you make that pool of volunteers smaller for yourself. A deadline that's set out 3 months or 4 months in the future can potentially capture a much greater number of volunteers. It'll be more attractive to them, it will be easier to integrate in their schedule, and you'll have better luck. So the minimum is 8 weeks, but if you can set it out longer, it helps us and it will help you a lot. So that obviously you have to make decisions about the case deadlines and what's appropriate and responsible for you and your client. But if you have that time, I strongly encourage you to use it. Okay. So now we're going to talk about the second big issue that triggers back and forth on case screening and can slow down the process for you. And that's an unclear forensic question or referral question. What I'm talking about when I talk about this is a clear explanation of what the client's physical and/or psychological concerns are. We want to know what specifically about this client needs to be documented or explained by a physician or a mental health professional. This question really should be identified by the attorney in advance of us getting the intake form, but sometimes when it's missing, we'll take time to work with that attorney and define it. But all of that can take up time, and it shortens the space between submission and deadline. So what are we screening for when we're screening for this forensic or referral question? These are questions that are beyond the scope of an evaluation. So an example would be an attorney says, I'd like a psychologist to evaluate my client to confirm that she has a well-founded fear of persecution. It's actually not uncommon that we get requests that are phrased that way. And of course, a well-founded fear of persecution is a legal conclusion. It's really one for the judge to make, and it's an argument that you're making, but it's completely outside the scope of a clinical evaluation. It's not a conclusion that an evaluator really should be responsibly drawing. So there, we would need to refine that question. Questions that aren't specific enough to give an opinion. So a question that says, I'd like to know if my client has been affected by this experience. It's quite broad, and it's not doing the work to narrow and focus a couple of questions for the evaluator to tackle in a 2-hour or 3-hour interview. This is sort of similar to a general request that isn't related to a specific client. You'll notice that most of these bullet points relate to a mental health evaluation request. Those are the trickiest places to define the question, especially if you haven't been able to spend a lot of time with the client yet. It can come up in physical evaluations. We do not pass on evaluation requests if there are no scars, no marks, no apparent disabilities. There just wouldn't be a reason to conduct a physical evaluation in that sense. So why are we doing this screening process? Again, it's because of our limited resources, and we want to be careful in how we deploy them. We don't want to be processing cases and placing them with volunteers when there's an extremely low likelihood that there would be any findings or any reason for that report, when we unfortunately live in a world where people go without these, and people who make requests to us go without these because our capacity is not as big as we'd like it to be. So we try to be quite careful about making sure that these cases are reasonable cases to send to the volunteer network. In addition, it helps you in two ways. One is that volunteers are much more likely to take on a case when there's a clear description of the nature of the claim, what the client experienced, and what the attorney is looking for. If there isn't that sort of clear explanation, the volunteer is probably going to expect that they'll need to do more work to sort that out, and it's going to take up more of their time, sort of coaching potentially the attorney to figure out what their question is. And then secondly, you're much more likely to get a more powerful report if the evaluator is going in with a clear sense of what the problems are, what the potential questions are, and the legal challenges. You don't want your evaluator meeting with your client not knowing that there's a one-year issue that they should be looking into. They're going to come out with a report that isn't very valuable to you, and they might not be able to go back in and do a second evaluation. So we work with you, we work with all attorneys to try to refine that question. We will do that, and we'll let you know if there's a problem with it. But the more you can define it in advance, the faster the screening process will go for you. Okay, so we've received your request, we've screened it, everything is clear, and now we're conducting outreach. So what does that look like? A lot of people think that we have a waiting list, and we'll get a lot of questions about where does my client stand on the waiting list, are they close to the top of the list, and that's actually not how our process works. We conduct outreach on nearly all open cases all the time, with some triaging for really urgent deadlines. So we're taking almost all of our active cases for a particular area, we create a de-identified case summary, and we send it to our active volunteers for the locality. Anyone, the psychological evaluators, the physical evaluators. And we ask them to select which cases they can take. The one instance in which we might not conduct outreach on every case is if we have, say, 30 or 40 active cases in New York City, and 10 of those have deadlines in 2018. We would probably conduct outreach on the more urgent cases, and once a few of those have gotten picked up, add in the later cases. But for the most part, almost all cases are getting outreach. We wanted to share with you a sample of a de-identified case summary. This is a case composite, so many details have been changed here, but it's a typical type of case that we receive, and this is a fairly good, strong case description. I want you guys to see this because this is what a volunteer sees, along with perhaps 10 or 15 other similar case descriptions when they're deciding whether or not to take a case. So they have the location, they have the age, gender, country of origin of the client, what type of evaluation they're seeking, and they know the legal office that's representing this individual. There's a snippet about, and we pull this from the details of the case on page 2 of your intake form, as well as any screening we've done. There's a snippet about the nature of the claim, what happened to this person, and the attorney's reasons for seeking an evaluation. So here we see that the attorney has some concerns about the client's inability to discuss trauma and some suspicions about potential sexual abuse that they'd like the evaluator to look into in the evaluation. And then, of course, we also have the deadline. So potential evaluators, they're looking at deadlines, they're looking at the nature of the case and the nature of the evaluation request. And they're also looking at, I just want to acknowledge, the legal office, right? We're going to go through later in this presentation how you can manage your relationship with the volunteer clinicians. You really want to become adept at that, because when and if there are repeated problems with a particular legal office, say, you will get volunteers who no longer want to work with that legal office. So you want to make sure that you and your colleagues all have a good sense of how to work with the PHR volunteers so you can keep those strong relationships and make sure that, again, you're maximizing the pool of potential volunteers. Okay, as we're conducting outreach, we're thinking about who can take on this case. And some of that has to do with location, and some of it has to do with the profession and their experience. Generally, for physical evaluations, we're looking at a certain set of evaluators. For the majority of cases, it'll be physicians, but we have physician assistants and nurses in our network as well. For mental health evaluation requests, generally psychiatrists, psychologists, LCSWs, and licensed professional counselors. I do want to note that GPs can conduct psychological evaluations if they're sufficiently experienced. For a family medicine doc, for an internist, a part of their regular clinical practice could include the diagnosis and treatment of mental health disorders. So it's appropriate for them in those cases to serve as experts in that area. But not everyone is comfortable, and so we try to carefully negotiate which of our GPs take on psych cases or combined evaluations where they're doing physical and psych. We do receive competency evaluation requests, but I want to note and manage expectations, we have less capacity in this area. Not all mental health specialists are comfortable taking on a competency evaluation, so almost everywhere in the country we do receive these requests, but the longer deadline we can have, the better, because it's a smaller pool that's out there that might be able to take them on. Okay, so at this point, we've screened your case, we've done our outreach, and a volunteer has raised their hand and said, I'd like to take on case number XYZ, and we're ready to connect you with that volunteer. This is our case placement email. Some of you have gotten these many times in the past. If you haven't, one of the handouts is a sample of a case placement email. We send this out immediately after the volunteer has indicated they can take on a case. There's no lag time, so you will know as soon as it happens that there's a volunteer to be matched with you. This is sent to you, the attorney, and the volunteer is CC'd. This sets out the responsibilities of both parties, and it triggers some steps that you as the attorney are going to need to take, most immediately reaching out to that volunteer to start to discuss the case. For the most part, you'll see that the case placement email is about 2 pages long. It's extensive. We have it that way because we want to be really detailed about everyone's responsibilities and expectations. So if you read through that carefully, you should be fine, but we're going to talk about some of the common issues that arise today so you can navigate around those. Okay, so we have now our do's and don'ts for working with volunteer clinicians. You'll see that most of the do's are just following the instructions that are contained in the case placement email. If you want to contact that volunteer directly within 3 business days, this is your chance to talk about the case, talk about their availability, and start working to plan the evaluation itself. You're going to need to arrange for a translator. Be aware of that in advance. I know that it can be challenging, particularly if you don't have the funds to pay for a translator. It's hard to find a volunteer, and it's hard to negotiate everyone's schedules. We totally understand that, but it's just something you've got to be prepared for when you start the process. You need to send the volunteer a draft of the client's affidavit before the interview. This does not need to be a final version. We understand that often you're going to be making changes post-interview, but it needs to be complete enough to give a full context to the evaluator. And then finally, please work to prepare your client for the interview. Make sure they know what to expect, what the connection is between their case and this meeting with a doctor or meeting with a psychologist, and make sure that they're going to be able to make it to that appointment. No-shows are tough. If the client no-shows, I understand that travel can be really challenging for some folks, but we won't always be able to guarantee that the volunteer can reschedule, particularly if there's someone who needs to find that time 4 or 6 weeks into the future. So do whatever you need to do to make sure that your client is supported to travel to the appointment, and you can help us if on your intake form you've clearly identified where your client can go and where they can't. If your client's in North Jersey but is just really not able to make it to the city because of anxiety, finances, whatever it is, let us know that. We won't try to place it with a New York City evaluator. So just the more you communicate to us, the better we can do for you. And then finally, if anything comes up, reach out to PHR. Let us know if there's a problem, if you're not hearing from the evaluator, whatever it might be. We want to be a resource to you, and we can often smooth things over or correct misperceptions as they're happening so that you can get things back on track. Okay, now the less friendly side, the don'ts. I know that I'm sure a lot of you who are here on this webinar, you don't do these things already, but I'm bringing them up because they do happen and they can really derail the process. So experts, please don't let a long time go by before you contact the volunteer. It does happen that folks will wait weeks or even months to reach out to the volunteer. Volunteers are agreeing to take on a case in a particular time period. If you wait 4 months to contact them, they may be out of the country. They may have picked up a heavier teaching load. They may have, in the interim, when they didn't hear from you, taken other PHR cases and now they're busy. They may not be able to help you at that point. So once you get that email, reach out right away. You don't need to be fully prepared, to schedule the evaluation that week, but start the communication so you understand their availability. It's so important. As a part of this, don't have your client be the person to make that initial contact. This happens rarely, but when it does, it's quite problematic. It's where things really get derailed. There's often a lot of confusion and misunderstandings between the clinician and the client on the nature or purpose of the evaluation, and we've seen things really go south when this happens. So manage that relationship, be the point person on logistics. It'll help things go smoothly. It's also how you start to build that professional relationship with the volunteer clinician, so that down the road, when you're having tough conversations about the report, you guys already have a rapport. It'll be much easier for you to negotiate. Good practices on translators. This is something you just need to be prepared to do as you're going through the process. And don't assume that the volunteer will be able to take on multiple cases during the evaluation. So if you're sending one client, don't send him with his siblings, assuming they can all have evaluations with the volunteer. There's likely just not going to be time for that. Submit separate intake forms for all family members, and we'll work to place all cases. We just need to have visibility on that. The final thing is the big one for us. I used to practice immigration law. I know how busy all of you are. I know all the administrative tasks that you have to do. But please, 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 if you've submitted a request to us and we're processing it, don't fail to let us know that you've placed the case successfully elsewhere. We will be happy for you when we hear that. We'll be delighted to know that your client is getting assistance, and we'll be able to turn our attention to other clients in the pipeline who need outreach conducted for them. It's not uncommon. Once a week or once every 2 weeks, we place a case only to hear that the attorney no longer needs the evaluation. For your client in the moment, I know that it's not a huge deal. They've received help. That case is going to move forward. That's great. But on our end, we've wasted resources on a case that didn't need them, and we have a volunteer who's potentially quite frustrated. Some volunteers, this has happened to multiple times, and in that case, the next time we send them a list of urgent cases, they're going to look at it with a skeptical eye, knowing that some of those cases may no longer need assistance. That hurts volunteer retention, and so it hurts the general pool that everybody is using for their cases. So please let us know immediately if you no longer need the evaluation. It helps us enormously to know that. We have right now probably 280 cases in our pipeline that we're conducting outreach on, and knowing that 15 or 20 of them no longer need our help is fantastic. We turn our attention to the other cases. So I know everybody tries, but I just want to drive home how crucial that is for us. So this is something that I include, and we actually have a very similar slide in our training for clinicians. This is just something I think is important to recognize and acknowledge, and it's not news to any of you, but there's a big difference in professional experience, background, outlook, and goals between you as immigration attorneys and a volunteer clinician who's doing documentation work. And that's okay, and that's part of what can make this process really invigorating, right, is the partnership between different professions. But it can also lead to a lot of misunderstandings and frustration. So I think it's good to just be aware of this, be open to it, and sort of give yourself the tools, and we'll try to do that today, to navigate it. We understand that your goals as immigration attorneys are to present the most clear, concise, and coherent narrative across multiple pieces of evidence for your client. That's what you're trying to do appropriately. That's not quite the goal of the clinician documenter. They are focused on the specific piece of evidence that they're producing. They want to provide an expert opinion on the consistency between clinical findings and reported background, and do some education for the fact finder about these issues. but their goal does not relate to the entire case and the narrative being presented. This comes up a lot when we get to the report drafting stage and report finalization stage. And so being aware of this as you go into that will help you navigate it. So I just want to call attention to it. And finally, PHR, I'll say this many times, is available to help when it comes to this translation. We're at the intersection between all of the attorneys and all of the doctors. We see the same conflicts and confusion over and over again, and we're pretty successful at being able to solve problems as they come up. So please reach out to us directly if you're having issues. Okay, so report drafting. The volunteer clinician post-evaluation will send you a draft of their report. If they're new to the process, they're going to send it to us first, actually, so that we can give them some comments and editing. I remember when I was practicing, I worked with PHR and got evaluations, and I would always have this moment when I got the emailed evaluation from the PHR volunteer of like a little bit of a stomach ache, because I'd be worrying, okay, is there going to be some big inconsistency in here or something I wasn't expecting, and then how am I going to negotiate that with the volunteer? And, you know, I had some anxiety about that process. So we want to talk through where things can go wrong today and affirm that you can handle all of those challenges, and it's totally appropriate to address certain questions. So there are a couple different categories of edits or comments you might want to provide when you get an evaluation. The first that are completely appropriate are comments on formatting and spelling. In fact, the volunteer may really need assistance on formatting. They might not know whether you require a formal notarized affidavit or if a sworn statement is sufficient, if you need numbered paragraphs. So that's, you know, all that's fully appropriate. Requests that are problematic are going to be requests that the volunteer add information that was not obtained during the evaluation. So, you know, I know that he didn't mention that he was sexually abused by his uncle, but he said it to me, and I think it's a big thing, and can you make sure to include that in there? That's really not okay. And you can avoid some of those issues by making sure that the evaluator knows in advance of any particular points you want them to address. Request that they revise their findings or conclusions, obviously that's problematic, or omit relevant details. Now the question is, of course, what makes a detail relevant? That's largely going to be up to the evaluator because they know what pieces of information on which they're basing their conclusions, but there's some room for negotiation there. It's going to require a conversation, and the biggest issue for everybody is inconsistencies in the client statement. It's what gives you guys heartburn, and it's quite common because nobody reports their story in the exact same way every time. So it's something we want to spend some time talking about today. And in order to talk about that, we're actually going to jump out of this sort of timeline we've been giving you of the life of a case into a bigger picture issue, and that's the Assemble protocol. The Assemble protocols are shorthand for the Manual on Effective Investigation and Documentation of Torture. Actually, I won't read the whole thing out. You can see it there. This is a document that was crafted in 1999 after years of analysis and research by forensic experts, physicians, psychologists, and lawyers from 15 countries. It's been recognized by the UN. It's an internationally accepted model for the documentation of torture. And the Assemble protocol is the basis for our trainings for volunteers and for the reports that we're asking them to create. So the IP, as people call it, contains legal frameworks, ethical considerations, detailed advice for how you actually go about conducting the evaluation, and it has standards for how you produce a report. And within the IP, sort of the fundamental question that documentation work is driving to is a question of consistency, the degree of consistency between clinical findings and reported allegations of abuse, torture, mistreatment, etc. This is not, it's important to note, credibility. Credibility is a legal determination that is going to be made by the judge, but it's consistency based on the volunteer's training and professional background. Are these findings consistent with what has been reported? Okay, so we just zoomed up to the IP, and now we're coming back down into our super granular walk through the process. Why is that relevant? Because when someone has conducted a forensic evaluation and is drafting a report in accordance with the IP, the background, the pre-torture history, the torture history, all of it is relevant, or much of it will be relevant, because this is the reported background in history that we have to decide, well, is this consistent with what we're seeing today, the reported and apparent symptoms? And so that's always going to need to be in the report to some extent, the client's story. And that is what creates these problems with inconsistencies, right? There's going to be some part of this that echoes what the client has reported in other places, in their testimony, in their affidavit, and of course we know it's very concerning when there are any inconsistencies. The immigration judge or the asylum officer might jump on that. So it's very appropriate to work to resolve these inconsistencies when they happen, and we expect that they will happen. What you want to focus on, and what we tell our volunteers to focus on, is relevance and materiality. Information from the history that is irrelevant to the findings does not necessarily need to go into the report. The report would be extraordinarily long in that case, and it would be filled with background that was just repetitive and sort of pointless. So it's completely appropriate for the volunteer to be only including certain portions of that client's reported history, but that they should be the portions on which that volunteer is basing their conclusions. We also tell volunteers that to avoid including specific dates and numbers unless it's absolutely necessary. Those are things that often lead to inconsistencies, and they're rarely specifically relevant to the findings. And again, talk to PHR. We're happy to help you negotiate this. We do it a lot, and I've done it as an attorney, and I do it now advising volunteers. So I understand it's complex, but it can absolutely be negotiated. I want to give you guys some insight. This is pretty close to one of the slides, again, that we provide to our volunteers in training on what not to include in their reports, just so you know what they're hearing from us. So again, details that aren't relevant to their clinical findings, medical jargon that's unexplained, cutting out all legal conclusions. And generally, sort of for the last two, the only things that we think should be in their report in terms of their opinions and their conclusions are things that they can defend based on their clinical and professional expertise under oath during cross-examination. That's like sort of the lodestar, the question that we say you should pose to yourself as an evaluator. And if you can't answer yes to those questions, you should be eliminating this from your report. So comments, on the political climate in a particular country, inappropriate, no matter the evaluator's knowledge of that country. That's not why they're there. So you've now successfully navigated the finalization of the report, and you've provided it to the immigration judge, or you've filed it with the papers. So what happens after that? If there's going to be testimony, that'll probably be the last stage of your intensive connection with the volunteer. So if there's going to be testimony, volunteers will know that usually up front. We ask you on the intake form, please keep them apprised of any changes in dates, any delays. Even if it's years in the future, make sure it's on their calendar and they're aware of it. And then you need to work with them to prepare. We tell volunteers to expect this, and many of them want it. They are rarely in court. Most of the volunteers, they look to you as the experts in this area. They want your advice. They want to make sure that they are preparing appropriately. So make sure to be in touch with them. Practice your direct and cross. Make sure that they're aware of what's going to unfold. Testimony is an issue that we train on, but it's important to remember that for many of us, for many of you, immigration or individual hearings are happening years after you've submitted your materials. And so a volunteer may have been trained and may start doing this work, but it could be 2 or 3 years or 4 years before their first experience testifying. So it's really good to work closely with them on that. And then finally, we have the case decision. Hopefully it's positive. Please do share it with us. One of the handouts is our outcome form. It's also attached to every case placement email, and it's available on our website. All of you have it. We collect case decision information so that we can have a clear picture of the impact of the work that we're doing. This is very important for us to be able to discuss why these services are valuable, why people should invest in them, and to make the argument that this is a part of essentially, due process rights from our perspective, that people have access to this type of service. In addition, volunteers who hear about positive outcomes are much likely to continue taking cases. So again, making sure that we've got that data helps to keep that pool of volunteers large so that you're more likely to get assistance when you need it. I do want to note, right now, our outcome form, and it's been similar for, I think, years and years, is a fillable PDF. I know it's a bit of a headache to download that, fill it out, save it, send it to us every time. We're working on developing an online survey for outcomes that we think will be much easier for attorneys to complete. So hopefully, by the end of the year or early in 2017, that's something that you'll start to see from us, and we're hoping that that helps us collect more data, more outcomes. Okay, so that we just went through the whole life cycle of the case, that first slide that you saw that was so busy. And that's it really for the body of the presentation. Just tying it all together, the big top line recommendations: request early, make sure you're completing the form fully. If you have any questions, let us know. This makes things move faster for you. And think carefully before you fill the form out of what it is that you need documented. It might be that you need to spend a few more appointments working with your client to unwind the complexities of their case and the concerns you might have about their testimony, about their story, that you'd like someone to focus on in an evaluation. That will be time well spent for you, and you'll have a stronger report if you do it. Build a professional relationship with the evaluator. Communicate early and often with them. This will help you This will give you insight into what they're thinking, then insight into what you're thinking. It will help you negotiate much easily that report crafting process, and you'll probably, again, end up with a stronger report. And finally, use us as a resource. We want to be helpful if we can be. We see problems a lot. We're familiar with most of what can go wrong, and I have been in your position before, so I'm quite sympathetic to the challenges that you all face as really busy attorneys. So reach out when something goes sideways, and we'll try to write it for you. Okay, so that's the conclusion of the presentation. I know that was super information heavy. We're going to send the materials to you so you have them in front of you, but I want to turn now to questions. We've got about 5, I think, questions, a couple from one person. So let's see. Okay, so the first question is whether or not we have recruitment materials for health professionals. We do. We have lots of information that we share with interested health professionals as well as new volunteers, and there is a place for potential volunteers to sign up to be notified of trainings. And we'd be happy to share that information with all of you after the webinar when we send out the link to the webinar itself. We can also send you a link where you can share it with others. You can sign up yourself to be notified of trainings at PHR if you've got professionals that you work with regularly that you'd like to share this information with. Okay, the next question is whether we do placements only for nonprofits or also private attorneys in reduced fee cases. We do placements for any immigration attorneys. And this has long been the case, and in fact, I would say in the last 4 years, we actually stopped collecting information on whether or not a case was pro bono. I feel pretty strongly about this. I know that there's a huge dearth of legal services, particularly immigration legal services. Whether or not an individual has managed to secure pro bono legal assistance or private legal assistance has very little to do with their ability to pay and the strength of their case. So we don't want to penalize a particular set of individuals who live in poorly served areas where there aren't a lot of pro bono or low bono legal services organizations. We don't ask on the intake form, we accept all cases, and we work to place them. And we take a pretty strong stance with our volunteers that we don't want to be sorting clients based on their financial relationship to their attorney. The next question is about how we safeguard information on the intake form. Particular concern for attorneys who may be helping clients with both immigration cases and civil cases, and how are draft affidavits and reports protected. So all of the information that we collect, first of all of our communication and our systems at PHR are password protected, and Janine and I are the only ones that have access to certain information in our databases, and that includes the information about your clients. We use a database that is secure, our system is secure, and whenever we're thinking about new tech tools we might want to adopt to collect information, paramount in our minds is the security of your client's information. For draft affidavits and affidavits that we're maintaining on record, all of those are redacted. And we're, again, pretty serious about that. We want to make sure that there's no chance that any of this information could be used against clients or could complicate a case, and we take our role as stewards of your client's data very seriously. Okay. Is the process the same for NQRP attorneys? That's a, oh, excuse me, I think I missed something. Okay, I apologize. There's a question about the 8-week deadline, yes, and working with individuals in detention. Andrea, I completely understand the concern. As I said, PHR does work with detained individuals, and I know that the deadline is a challenge if you're an attorney working mainly on detained cases. Those cases move on a much faster timeline. It's closer to that of like juvenile asylum cases in a lot of places, and unfortunately, we don't have a separate track for detained cases that allows us to take them on a faster timeline because we don't have a separate pool of volunteers. So it's for that reason that we don't do a huge volume in detained cases because it's just not always possible. The only thing that I can say, and this is, it won't always be possible for you, but is to request as soon as possible when you know that you're taking on a case to maximize that time. I know that in some instances, attorneys will request an adjournment, and we're always happy to submit a letter in support of an adjournment request, but I would never assume that that's an easy ask. I understand that it means more time in detention, and so we don't assume that that's possible. It's a challenge for us, and I think it's a challenge that we could only solve by increasing the size of our volunteer pool. Then the intake process is the same for, NQRP attorneys. Yeah, we have one intake process for all cases, and that's really the only way that we could manage it, given the volume. I assume that you're talking about an intake process for competency evaluations. And again, we do those, and it's something you would just want to indicate on the intake form. Our capacity is not as strong there, so longer deadlines help. But I know that there you're juggling the detained issue. So it's a challenge, but the more information you give us, the more we can try to work with you if possible. Okay, someone has a request. This is a request about a specific case, I guess, that has been pending since February. Ashley, I'm going to encourage you to reach out to us, either Janine or myself, directly. It's hard to answer this question in this form without knowing where the case is and all of that. In a general way, I would say that some cases pend for a long time if it's a high volume area and if you've set a particular deadline. But we can talk more about that in detail offline, Ashley. I'd be happy to do that. We have, the next question is whether or not PHR has ever been subpoenaed for information relating to a case that was processed through PHR that has never happened in the 25-year history of the program. I would not expect that it would happen, but Diana, if you have a particular concern about a case you're working on, I'd be happy to talk with you offline about it. Again, it's never happened before in the life of the program. There's a question about the copies of, can you guys get a copy of my notes for the presentation? I'd be happy to share those with you as a part of the presentation itself when we send it out. Okay, so it looks to me like that's all the questions folks had entered in. I see 2 people who have their hands raised. Jim Revis, and is there still someone else? And Mevlud. Okay, let's start with Jim. Just bear with us, folks. Okay, Jim, you're unmuted if you want to ask your question.
Well, my question is, I really appreciate your support. You've helped me out in several cases. And I've got one lady that I really needed fast action on. I was going to ask you about that, but I think you sort of answered that in your presentation.
Gotcha. So yeah, it's an urgent case. Yeah, I understand, and I wish we could do more on those urgent cases. It's an allocation of resources question, and this is sort of where we've set the line. So again, hopefully as we grow and we bring in more volunteers, our capacity will change, and we would communicate that to attorneys if it did. But thank you, Jim.
Thank you. I appreciate all you do. Appreciate it.
Okay. And then Mevlud, you are unmuted if you want to ask your question.
And yeah, and Aston was probably one of them. Yeah.
Hello? Hello?
Hello?
Hello. Yep, you are unmuted if you still have a question you'd like to ask.
Oh no, sorry.
Oh, okay. No worries.
Thank you.
All right. Thank you. Okay, so it looks like we're just coming up on 4 o'clock and there are no further questions. I want to thank everybody for attending the webinar. We've got 83 folks now. That's great. That's really exciting. And again, we're going to make this available to more attorneys in the future. And you know, I think this was, I think it went really well. I was glad to have the conversation. We can also maybe try to do an updated one in the future as trends and situations change. So thank you all for your time. We'll be following up with materials after we close out of the webinar. And I hope you have a wonderful day.